following on with our 90-year-old female, and still in the room, the paramedic is still in the room with the daughters. The family then stated that the hospital team, during attendance and also discharge, had not informed the patient of her diagnosis. And in discussion with the family, as they felt it would be bad for the patient's mental health and a potential relapse of her delirium and confusion, which had been affected during the hospital admission. The paramedic discussed with the daughter that they advised the patient to attend hospital for further investigation, and that was due to the potential causes of pulmonary embolism, heart failure, pneumonia, and untreated cancer-related symptoms. The family then highlighted that the patient's unwillingness and likely refusal to return to hospital. They again asked that the patient not be informed about her cancer and asked if the crew could omit or white lie about the cause of the pain and recent decline. The patient did not have a lasting power of attorney for health and welfare in place, or an advanced care plan, and was assessed as having mental capacity at the point of the attendance. The clinician highlighted to the family the ethical, moral, and legal concerns they had with withholding information from the patient and the ability for the patient to make an informed decision about her own care without all of the information pertaining to herself. The paramedic also felt that it was not their place to break this challenging and emotionally fraught news, as they did not have all of the information surrounding the diagnosis or many of the answers to questions which would likely arise. And then over to Chris, I'll pause there.
Hi, everyone. So I'm just a paramedic, same as everybody else. I'll start with that. And so I went to study medical law so that we could analyze these questions as paramedics and try and put the law into an accessible and paramedic understood way. So hopefully that's what I'm going to try and do and make it short. So I'm trying to just get these slides to work. 2 seconds. There we go. So the first thing I plucked out, and we've already had a big discussion about that, the only reference in the narrative that I could find was about the patient's wishes, really, was that she didn't want to attend hospital again. However, there were some of the daughter's wishes there about not informing the patient of a terminal illness, and due to a potential deterioration in her mental health and a relapse of a delirium or confusion. And this was well-meaning. They wanted to protect her mother, and the daughter had said to the paramedic that she wanted to spend the remaining time left with her together, probably not upset or in any kind of treating her as a terminally ill person, or a mother changing her attitudes towards her and things like that. So to run over the legal framework, the Mental Capacity Act certainly comes into play here, and we heard that the paramedic on scene assessed that the patient had mental capacity, and that plays an important part, because now we've got to decide, if she's got mental capacity, how can we make any decisions for this patient with proper consent? Because if, even though she wants to not go to hospital, she's making that decision based on an absence of a large amount of information, i.e. a terminal illness diagnosis. So any actions that I see performed by health professionals in this case could be argued as non-consensual and unethical, because the patient doesn't know the reason behind the decisions that she is being asked to make or not make. And then I'm going to look at some of the cases that have been raised, that have raised these issues. So you might be familiar, if anybody's done advanced life support or any resuscitation updates in the last few years, the case of Tracy in Cambridge hospitals, which is underpinned do not resuscitation training, DNA CPR orders, resuscitation training since 2014. And is, if anybody's heard about this case, this lady was terminally ill with lung cancer and had a road accident. And unfortunately, she was driving a car. She was fairly fit, even though she was ill, and was driving a car and was involved in a road accident, was rendered quadriplegic. And what happened in hospital was this lady was subjected to a do not resuscitate order without her consent and without discussion or involvement in her care. Now, it came very clear during this case and during the court case that this patient wanted to be involved in her care. She was approaching medical staff who were treating her, asking her about her health, about the state of her health. The family only found out that there was a do not resuscitate order on her when they had a look at her notes, and it came as a big shock, and nobody had been involved in a discussion with that patient. So the judge, or one of the judges in the case, Lord Justice Ryder, he actually said that the duty to consult the patient is integral to the procedural obligation to ensure effective respect for the Article 8 rights. So what does that mean? Well, that means that consulting the patient, or not consulting the patient, engages their Article 8 rights to a private life under the European Convention on Human Rights. So by not involving the patient, we're potentially overriding the rights, this person's fundamental human rights. That interest is the autonomy, integrity, dignity, and quality of life of the patient. So to come up with a decision not to discuss with the patient, and this is not a criticism of the paramedic, this is a criticism of how this case arose in the first place, is that potentially by not telling this patient or giving her the information, we've overridden her dignity. We've not given due respect to her autonomy, and it could potentially affect the quality of life of her care, because if she doesn't know she's terminally ill, how is she going to access the relevant medical care and treatment? As it says, that process is individual to each patient, albeit informed by good clinical practice. So, as we mentioned in the group discussion earlier, although autonomy is key to that decision making, she could make the autonomous decision not to want to know what is wrong with her, but unless somebody asks her, how do we know what her values are and what her basis is for making that decision? So I think, although the case of Tracy is about do not resuscitate orders, I think the comments there make a very powerful statement about how integral that discussion and our duty to consult is with our patients. A recent case from the Supreme Court, Montgomery, this was about consent. And in this case, it was a maternity case, and this is about giving information and what level of information is required to give to the patient. And here, there was a very powerful statement by the Supreme Court that the doctor is under a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative. So I think we've got to ask ourselves, in the case that we're discussing, was how can the lady be made aware of any recommended treatment if she doesn't know what she's being treated for? So, in my opinion, it's a wholly unlawful and unethical way of treating the patient. The doctor, however, is entitled to withhold from the patient any information as to risk if he reasonably considered that its disclosure would be seriously detrimental to the patient's health. So I think here, in our case, the paramedics acted in a really good and effective way. We haven't heard the whole story from Antonia, but the paramedic will go on to discuss, and multidisciplinary teams will be involved. And I think that's a really important way that the paramedic dealt with this case, because I don't think the paramedic dealing with this lady would be in a position to know if she gave that information to the patient, whether that the risks recommended by the daughter, so a risk that it will be detrimental to my mother's health, it will be it could lead to a deterioration in her mental state and things like that. The paramedic in this case wasn't in a position to know the full medical history of the patient, and whether that, if she did disclose that terminal illness disclosure, whether there could be a reasonable detrimental to the patient. However, going back to the case of Tracy, in that case, they absolutely determined that just upsetting the patient is not seriously detrimental. We can't just withhold information if we believe it's going to cause upset. It's got to be a serious deterioration in that patient's health. And that's a key point in that case. One of the first cases that really sparked my interest in medical law was Miss B in a hospital trust. And I think Baroness Sloss, then Dame Sloss, who was president of the family court, she made some very powerful statements in this case, which was a lady who had been rendered quadriplegic by a brain hemorrhage and was unable to breathe for herself. And she wanted to be removed from the ventilator and be allowed to die peacefully rather than be kept alive. And in this case, the judge agreed that it was her decision and it's her autonomous decision, and described what she called a benevolent paternalism, which I think the daughter here was engaging in her parents. The daughter had took on a parental role over her mother, and albeit a well-meaning paternalism, but she'd taken over this parental role and decided that she didn't want to hurt her mum by giving her this information. And I think this is a case where this benevolent paternalism was definitely demonstrated, and how we get over that. I think we can have ethical discussions about whether families are allowed to take a more paternalistic role over their relatives. At the end of the day, we all accommodate what our relatives want. We all make sacrifices to our relatives. So there could be ethical discussion about whether actually it is ethical to take a more paternalistic role over members of our family than, say, a doctor taking a paternalistic, or a paramedic taking a paternalistic role over a patient who they say, I know better than you. And sometimes families do, and they do make accommodations. However, the law views the patient's autonomy above everything. It's although the courts respect the sanctity of life, they don't see keeping people alive at all costs above that patient's autonomy. So in this case, the court found in favour of the claimant, and she was allowed to be removed from the ventilator, and said that she'd been treated unlawfully for 18 months. So I think that just goes to show how Sorry, I don't know what's happened there. I think that just goes to show how much courts view autonomy over and above other ethical and relative discussions about how we treat our patients.